Well, good morning, everyone. Hope everybody is about to enjoy a beautiful summer-like day coming up here. Starting off today, just a couple of notes. First of all, for those of you that were at the agent appreciation event, just fabulous time. I'm glad you could get out and see everybody and have some great food and drink. And it was just really, really nice to see everybody. I know between Colleen and myself and the staff here, we did a lot of stuff in the background to get ready for that, hoping that it would all turn out. And the one missing piece was the weather, which I have to tip my hat to Colleen. She was in charge of the weather and did a phenomenal job there. So hopefully you had a great time. And Colleen, I don't want to put you on the spot here, but I know one thing that we're waiting on at this point in time are the t-shirts, and they're going to be ordered. Can you just review with everybody, if they haven't ordered one, what to do at this point in time?
So good morning, guys. If you have not given Marion your shirt size yet, then make sure you do so by Friday so that we can get those shirts ordered. And then I would imagine it'll take us about a week and a half for the order to be processed. And then I'll pick them up and bring them back here to the office. Marion has a spreadsheet, so just send her an email with your shirt size.
Okay, thank you very much. Another completely different note, hope everybody got out to vote yesterday. It was a great day to vote. I know I read on this morning's Penn Live site that the two big things that were questions on the ballot had to do with limiting the governor's emergency powers to 21 days versus unlimited, which is what they are right now. And that has passed. So for those of you that got out there and voted, I think it was a positive thing for our state. The vast majority of states across the country limit the governor's powers as far as how long he or she could lock things down. So there will be an amendment to our state constitution coming up, I'm not sure when, that will actually limit the governor's powers to 21 days, and then it goes to the legislature to see if they would like to continue on. So that was a big item on the agenda. So thanks for everybody who voted for that. Appreciate it. I'm going to share my screen here. Okay, takes me a while to get it all set up here initially. We're going to talk a little bit later on today about the importance of client-agency relationships. And I think a lot of times we kind of ignore this and we just take them for granted and we kind of gloss over some of the paperwork. So I'm going to kind of bring that back to the forefront and just share with you some things about how we got to this point in the real estate industry where we do have these client agency relationships. But before we get into that, we have a number of other things, including our Homesale mortgage team. I know Dan and I talked yesterday, and there was some, excuse me, there is some confusion, and Dan sees this quite often, about what kind of inspections are required when you have various types of mortgages. So I'm going to turn it over to Dan.
Morning, everyone. So yeah, I just wanted to clarify a few things, obviously, in the environment that we're in with competition and offers and frequently waiving inspections of, all inspections, some inspections, whatever it may be. Obviously, specific mortgage programs do have specific requirements for inspections. So one of the first things I wanted to tackle was just an explanation for something. So PHFA, which is Pennsylvania Housing Finance Agency, they are an entity that essentially offers purchase loans for home buyers through traditional mortgage programs. So basically, if somebody is using PHFA for a mortgage, they can be doing conventional financing, FHA financing, USDA, or VA. So I wanted to clarify that because I fielded some calls and questions from just agents, buyers that I guess a little bit of misunderstanding that somebody can utilize conventional financing but utilizing PHFA as far as the program because they are a first-time home buyer, and there is, many programs such as subsidized interest rates that make it favorable for a first-time home buyer to utilize PHFA as a program as a whole. So I just kind of wanted to clarify that. Now, if a buyer is using PHFA, PHFA has their own specific requirements when it comes to what type of inspections are done. And this is, regardless of the type of mortgage program, not to be confused with just traditional programs. So I wanted to tackle PHFA first. So first and foremost, because we live in such a fluid environment when it comes to mortgage guidelines, I literally got an email at 10:38 this morning, which changed some of this information on the PHFA breakdown. So the first thing I want to tackle, because this is probably the biggest one, is a water quality test. So PHFA does require a water quality test for a private water supply, regardless of the type of program. Now, the updated information is, as the screenshot says, full panel, which generally means testing for all elements. PHFA just essentially came back and confirmed that the only thing that needs to be tested is coliform. So that's the only element that needs to be tested when it comes to private water supply for PHFA is the zero coliform. This gets a little confusing because obviously if somebody is doing USDA or FHA, the requirements are different. So think of that as just the conventional requirement. Also with PHFA, septic inspection, obviously it says it's only required if the appraiser indicates some type of concern, or if the property is vacant, a hydraulic load test is required. And a pest inspection is always required with a PHFA loan, again, regardless of whether it's conventional, FHA, USDA, or VA. One thing I also want to point out is that Homesale Mortgage does not offer VA financing through PHFA. And that's simply because of our relationship with Town Bank and essentially being a joint venture. So I won't get into details, but just keep that in mind. Otherwise, looking down below, this breaks everything down, which is pretty standard across the board. So conventional FHA, VA, and USDA, this lists the different inspection requirements. I won't go through each and every one of these. They're pretty self-explanatory, but I think this particular document, and I'll update it or have Tom update it for the water quality connected to PHFA, but everything else is going to be the same across the board because these are agency guidelines. They're not specific to Homesale Mortgage. So as far as the water quality test, the septic inspection, and then of course the pest inspection, this breaks down what is and is not required on every mortgage program. So just keep that in mind when you are waiving certain inspections. Obviously, if you're working with James or myself, feel free to reach out to one of us as you're writing the offer, just so everybody's on the same page as far as what inspections you are required to have and what ones that you would be okay waiving. So that's all I have. If you have any specific questions, again, you can reach out to either of us. And I know James wants to touch off on one additional thing as well. Thanks for your time.
Yeah, just a quick thing, an update that came through with USDA last week. I know right now with the market, USDA is not generally a type of financing that we're seeing, offers get accepted on. But, when things do open up a little bit more as far as kind of shifting towards the buyer's market, maybe USDA can come in handy for some people. But they increased their income limits for USDA last week. So a household of 4 or less Now the household income limit is $95,450 for Lancaster County. And then for a family of 5 or more, the household income limit is $126,000. So, I know a few years back, these numbers were a heck of a lot lower. So it's nice to see them kind of keeping up with things. In the surrounding counties, York is just a little bit below what Lancaster County is at. Berks County is pretty much, if I'm not mistaken, on par. They're about the same as York, and it's only about $1,000 difference for household income, and Lebanon's about $3,000 lower. So just wanted to put that out there, keep you guys informed on that. And once in a while we see a USDA buyer get an accepted offer, but as you guys know, it's really tough right now. So if you have any questions on that or anything specific to USDA, just let us know.
Thanks, guys. Appreciate it. And just a side note here, Dan did mention, but I do want to reemphasize that what you see on your screen here, Dan actually gave me a handout, so I will include that with the stuff that I send out to you. In addition, I always publish the slide deck here. I'll make sure that before I publish the slide deck that I make the revisions that Dan talked about, so there's no confusion there. Up next is Sarah with Homesale Settlement Services, who wants to talk about an issue that she's run across not just recently, but consistently over time. Sarah?
Hi. So good morning, everyone. I have actually had this come up frequently the last couple of weeks from sellers directly. We'll be processing a file and we call a seller or a seller's agent and say, we haven't gotten the seller's authorization letter back. And the seller says, well, you mailed it to the property address. I don't live there. And my response is always, well, I looked at the agreement of sale. There is no mailing address listed underneath your name as a seller. So we just assume you live at the property. So when you guys are doing, buyers or sellers or getting contracts or writing contracts, it's important to remind either the listing agent or when you're reviewing a contract to let the buyer's agent know, hey, this is not the seller's mailing address. We need to fill this information in. Items do get mailed out, and if we don't have them, we can't mail it. And I think that goes the same for the buyer's mailing address. Those boxes underneath are there to fill in the proper information. And the more information that we have, the faster things can get processed and done, because a lot of people are selling investment properties right now. So they're not living there. And if we don't know where to send it, we could have a delay in closing because we don't have payoffs. And things didn't get to the right spot. So Tom has, where it's in red on the agreement, that box is to list if they live at 123, Market Street, even though they're selling, 536 Main Street. So I just wanted to let everybody be aware when submitting or writing contracts, let the listing agent know or double check for your sellers that the right information is put in there. Tom, I don't know if you want to say anything else about that since you help them with the agreements as well.
No, and we don't know as people who review these agreements. I know staff doesn't know whether the person lives there or not. So really the only people that know are the people, the buyer's agent and the seller's agent. So it's incumbent upon you to just make note of that. I mean, from the buyer's perspective, if you are showing a vacant property, more than likely the seller is living at a different address. So I would try to find out from the seller, or excuse me, I would try to find out from the listing agent where the seller is living so that, we can make the appropriate entries in our paperwork.
Or even suggest when you submit the offer to the listing agent or it gets accepted, hey, can you please make sure that you fill in at the listing agent the proper mailing address for your seller on page 1 underneath their name. I don't think there's any harm in asking that.
Okay.
That's it.
Thank you, Sarah. Appreciate it. Up next is James White with Homesale Insurance.
Good morning, everybody. I just have a quick topic. I had Dan Rank who had a question about this last week, and I thought it'd be good to share regarding trampolines at properties. And insurance companies look at it many different ways for those of us with trampolines. And I've noticed too, a lot of people, a few more people have gotten trampolines than in the past because of the pandemic, something for the kids to do basically. So insurance companies, as I said, have different views on them. Some don't write trampolines at all. One of my local carriers that doesn't write it would be Lidditz Mutual. And some will only write with netted trampolines. Some would actually require a fence to be around the yard. So that happens occasionally as well too with one of my carriers. And the ones that do, some of them actually do add what's called a surcharge, which is an extra charge to the policy, to that individual policy. And one that I know that does that is Donegal, another local company as well too. I think the last time I checked, it was $50 extra for a trampoline to be on a Donegal policy. And then the rest of them that do allow trampolines, they basically factor it into their rates for the entire state that they're writing business in, basically. So they basically just spread it amongst everybody. So that was basically all I had for today. And thanks for your time.
Thanks, James. Appreciate it. Okay, late last night, I think everybody got an email. Probably one of the most welcome emails we've had in a long time. Rod and the leadership team have been working on this and working on policies. And I've put them here on these slides, kind of capsulizes or summarizes what was in his email. Effective May 19th, and if everybody looks at their calendar, that would be today. May 19th, fully vaccinated individuals, masks are no longer required in our buildings, and social distancing is no longer required. Now, you notice that there is an asterisk next to fully vaccinated. If you go down to the bottom of this slide, I actually fall into this category because I got my second dose of Pfizer last weekend, or excuse me, 2 weekends ago. So I'm coming up on my 2-week period of time. So between today and the weekend, I'm still going to need to wear a mask around the public areas within North Pointe. But once I get beyond that, I can do away with the mask. You will notice that our lovely admins have been vaccinated for quite some time. And if you walked into the office this morning and saw Janice and Marion, they are maskless. Nice to see them actually again. As far as unvaccinated individuals, mask wearing protocols remain in place for those individuals. Same thing having to do with social distancing. And please, as you're going through the building, we have little bottles set aside all over the place to sanitize your hands frequently. In addition, probably most important are what happens when people visit our building. Now, right now, if you entered our exterior doors and came into the building, we will have a mask required there. That will come down today, and we're essentially going to be putting up bullet points that reflect what I'm reviewing here. The vaccination status of any individual, notice it's underlined, any individual entering our real estate office will operate on the honor system. We appreciate everybody's, doing the right thing. We're going to ask people that do come into our building, you're on the honor system also. We are going to continue to register visitors and vendors that visit our building at the front desk. So we are going to continue to have those people fill those things out just in case we need to do contact tracing because of a COVID issue that might occur within the building. In addition, you see down at the bottom here, effective June 1st, which is fast approaching, all our building capacity limitations will be lifted. So we'll be able to gather within the buildings For those of you that have had some reluctance to come back into the building, you know, you may want to continue to stay at home. You're more than welcome to come back, but we don't have any restrictions on the percentages like like we did in the past. So once again, we have more COVID-19 protocols. I think this is the 57th time I've gotten in front of you on a Zoom call to share with you things that have changed. Hopefully this is for the better. Now, one side note, which is not on here, because June 1st, those limitations are going to be lifted. And in addition, vaccinated people can gather. Our second sales meeting in June, I am going to hold a live session in our training room. Probably be the first one in almost a year and a half. Now, I'm going to put something out to the office asking you about, you know, do you prefer this Wednesday 11 o'clock time, or do you like the time that we had previously, which is going back to, let's say, a Tuesday or a Wednesday morning at 9:30 in the morning? I'm going to try to get the pulse of our group to see what the preference is now that we've had the experience of doing these Zoom calls at 11 o'clock on the first and third Wednesday of every single month. So things are changing, hopefully for the positive. I do appreciate everybody's patience with me and Colleen and trying to convey these protocols to you over the last number of months. I know it's been confusing for you. It's been confusing for us. It has been confusing for the leadership team because we're trying to balance a lot of different things, CDC guidelines, state protocols, what PAR's guidance is. There's a lot of different things that we're getting input on. So hopefully, you know, we're getting through this, and it's going to be happy days are here again in another 2-3 months. So if you have any questions, please drop them in the chat box or see Colleen and I, and we'll be happy to address them with you. Okay, I played that because our Maryland group, south of the Mason-Dixon line, they hold an annual Sunshine Kids golf tournament. It was a very big success last year. This year's date is Monday, September 13th, 2021. So if you'd like to register for this event and, you know, once again, travel south a little bit, much appreciated. All the proceeds go toward the Sunshine Kids. And you see, I have a note at the bottom of this. You saw on the video a helicopter that dropped a whole bunch of golf balls at a hole. And you're probably asking yourself, what the heck is that doing in a golf tournament? Well, those balls are each numbered, and the ball that either goes into the hole or is closest to the hole wins a prize. Our leadership group at Homesale, including everybody in all of our offices, they have taken out a ball in your individual name. So you are entered in the helicopter golf ball drop. You are eligible to win $15,000. So I just wanted to make sure everybody's aware of that. Consider going to the golf tournament. You know, see some of your colleagues from our down below, once again, the Mason-Dixon line. And once again, it's a great event for Sunshine Kids.
Once you have downloaded the eKey app, you will need to follow a few steps to authorize it for use. Key holders can obtain an authorization code from SuperWeb or from your association MLS Super System Administrator. If you need to request an authorization code, the easiest way to do it is to open the eKey app. Tap Activate eKey. Tap I need to request an authorization code. Enter your email address or phone number on file with your 4-digit PIN. Tap Submit. Based on what you entered, you will receive an email or SMS text message. The next step is to enter the authorization code into the eKey app. The easiest way to do this is to open the email or SMS text on your smartphone and click on the link. This opens the eKey app and automatically enters the authorization code for you. Click on the EULA, End User License Agreement, and Privacy Notice. This will open the eKey app and you are ready to start using your eKey. The authorization code for the current eKey app is a 10-digit alphanumeric code containing the letters A through Z and the numbers 2 through 7. If the characters look like a 0, it is the letter O and not a 0. If it looks like a 1, it is the letter I and not the number 1. As an option, you can enter the authorization code manually. Open the eKey app, tap on Activate eKey, tap I already have an authorization code, enter the authorization code. Now you are ready to use your eKey. There may be a limit to the number of authorization codes that can be obtained each week. If you reach your weekly limit of authorization codes, please check with your association MLS. You have other ways to obtain an authorization code using SuperWeb. If the eKey app is installed on your device, you may instead select the SuperWeb icon on the eKey app. Enter your key serial number, PIN, and select your association MLS from the drop-down list. Select Login. Select Authorization Code. The authorization code is emailed to your email address on file with your association MLS. For further information, contact Super Support at 877-699-6787.
So this came across yesterday, and I wanted to make sure everybody was aware of this. A lot of people don't update their program, and the main gist of what I got out of this is if you're not updating right now, you're not going to have access to the lockboxes. So update it. There's also some old technological phones such as Blackberries, Windows phones that are now going to be obsolete. So you may want to check the website for further information just to make sure that you're going to have access to properties. So coming up on July 1st, the seller's property disclosure is going to change. It has been revised or is in the process of being revised. I am going to send out a red line version of this after the meeting so that you'll be able to see where the changes are. And as you might imagine, the seller's property disclosure is no longer going to be 10 pages, it will be 11 pages because they've added some things, clarified some things. I'm not going to go over all the changes, but I am going to highlight some things that are different on the new property disclosure versus the old property disclosure. And you don't need to worry about this. I've already been in contact with Kelly and she's aware. Come July 1st, which is when this new form is going to go into play, she's going to work with our .loop people to get it to us and into our templates as quickly as possible. So here are some of the changes. So there's going to be a direction box at the top of every single page that basically says, hey, in so many words, you need to fill this out. There's a lot of people, a lot of sellers that kind of skim over some of the questions in the seller's property disclosure. This is basically saying all questions must be answered. And as I said, this box will appear at the top of every single page. They moved the definition of material defect to the top of the first page. It was actually buried on the first page. And a lot of people had questions as to, what a material defect was. Well, as soon as you look at the new seller's property disclosure, that's the very first thing it addresses. So that if people get bored with reading 3 or 4 paragraphs, they'll at least read the first one, which tells them what a material defect is. They've relocated the executor, administrator, or trustee box to the first page. Here was the issue in the past, is a lot of agents would get seller property disclosures. They go to the first or second page and they see everything blank. And the first thing they think of is, oh, the seller failed to do this, or the listing agent screwed up. And you really wouldn't know unless, excuse me, unless you went to the last page and looked at this box that says, oh, I see why it's all blank. Well, they've actually moved this box to the very first page, which I think is a good thing. So you'll be able to glance right off the bat if one of these people or one of these roles, that's the reason why the seller's property disclosure is blank. You will note in the brief webinar that I was on, one of the questions that gets asked to our legal hotline, PAR's legal hotline all the time is a power of attorney the same as an executor, administrator, or a trustee? And the answer is no. So if you have a seller that is a power of attorney because they have, you know, they're signing on behalf of an elderly parent, they are still required to fill this out to the best of their knowledge. They can't just waive the right by signing in this box. In addition, they've added a box on the first page talking about common law duty to disclose. It's just one more thing that's saying to the seller, hey, you need to do this, not only because of our the State Real Estate Commission, but because of common law. So it's kind of backing up what the disclosure form is saying right off the bat. Here's one of the new sections, deals with solar panels, which we've had a sales meeting in the past on. You see the following questions are asked under electrical system. Is the electrical system solar powered? If yes, is it entirely or partially solar powered? And if yes, is any part of the system subject to a lease, financing, or other agreement? If yes, explain. I know I've dealt with a lot of agents in this office who have come to me and said, oh my gosh, I got this huge headache going on because my seller has these solar panels and the agreement is so convoluted as far as what we can and can't do. This hopefully will bring this to light that much sooner, so you address it prior to getting to an agreement of sale. In addition, there's a clarification here in basements and crawl spaces. Has to do with water. And it says, are you aware of any past or present water leakage, et cetera, et cetera? So if you are a homeowner now and you've lived in your property for 10 years, and you know for a fact that the previous owner had water leakage, you have to disclose that because it's knowledge that you have. So you notice the words past or present are now inserted in here, and it's a clarification. There's a whole new section on pools, spas, and hot tubs. I'm not going to read through all of them here, but they each need to be answered if in fact you do have a pool, spa, or hot tub. In addition, there's a brand new section having to do with windows, and I failed to update the bullet point there. That should say windows instead of pools and spas. When I was on the webinar, apparently the original windows section was about that long. And they got to the point where they all started asking themselves the question, does a consumer really understand this? Because they got into what a double hung window was, and there was all kinds of stipulations having to do with a various type of window. And at the end of the day, they basically said, no, let's just lump it into windows. And are you aware of any difficulty? I know some of our older homes, especially in the city, you have a lot of windows that either A, don't stay open, or B, have been painted shut like 5 and 6 times and don't open at all. So you're going to need to make a note of that in the seller's property disclosure going forward. Probably one of the nicest changes is that the answer boxes are going to be moved to the right-hand side of the page. You know that the answer boxes now are on the left-hand side of the page, and you say, well, what's the big deal? Well, here's the big deal. Most people, I think everybody in this call, when you read a sentence, read from left to right. And when you're done with the sentence, your eyes are already on the right-hand side of the page. And in the old version or the present version, you have to now go all the way back to the beginning of the page and line up where the sentence was with the box. And we ran into situations where people were filling in the wrong answers because it wasn't aligning with the sentence. So the yes, no, unknown, and NA is going to be moved to the right-hand side of the page, which will be a major improvement. They are also creating a consumer guide to the seller's property disclosure statement. I know we walk a fine line with consumers when they ask us, well, how do I fill this out? Or what do they mean by this? And technically, we're not supposed to say to a seller how to fill out the seller's property disclosure. Well, just like there's a consumer guide to the agreement of sale, there's going to be one, probably not on July 1st, but it's going to follow shortly thereafter, that we can download and actually give to a seller that answers a lot of their common questions about how to fill out this seller's property disclosure, which I think is a really, really good thing. In addition, not having to do with the seller's property disclosure, but one of the other things that the Standard Forms group is working on at PAR is revising the appraisal contingency to take into consideration the differences between a sale price and an appraised value, and how much of that difference the person is willing to make up. They're going to kind of standardize the language. I know from a manager's standpoint, I can't tell you how many different clauses I have read that try to address this, and some of them are really poorly written. So that's in the offing right now. So look for that in the future. Once again, it's probably not going to be here on July 1st, but that is going to take place in the very near future. I also wanted to highlight some proposed legislation that is being looked at in Washington right now. I know we as real estate agents, and especially as realtors who belong to NAR, we are often asked to respond to calls of action. And I know a lot of people just kind of brush them aside, but there's some really important stuff that's on the horizon. And when you get these calls to action, make sure you get in touch with your legislature and let them know how you feel. I'm going to highlight a couple of things here. First of all, there's something that is being created right now called a First-Time Homebuyer Act. It provides a tax credit of $15,000 or 10% of the purchase price. You see some of the qualification standards here. I'm not going to read all of them. I just want you to be aware that this exists. Now, this is my personal opinion on this, and I think everybody who's been in the real estate business over the last 12 months would probably agree with this. Our issue right now is not getting more buyers into the pipeline. Our issue right now is getting more sellers to put their property on the market. I believe that this is a personal opinion. I believe this is a total waste of time and money, and it's misdirected in the wrong area. We ought to be focused on the other side of the transaction, the seller side, and in a second I'll talk about builders specifically and getting more new product into the marketplace. So it sounds good on paper, but once again, I'm not sure anybody on this call wants more buyers. They have plenty of buyers, we just can't get them into homes. There's also a Housing Fairness Act that's being proposed. This increases HUD's budget by $18 million to be used for increased discrimination testing. In addition, they're proposing a $20 million increase for new resources directed to proactive agency-initiated investigations. If you haven't figured it out already, with all the stuff talking about discrimination and steering in the real estate industry, it's no wonder that legislation like this is being proposed. I think it's a good thing. I just bring it to your attention in right now, because if you've never been tested, and you've been in the real estate business for quite some time, get ready. You're more than likely going to be tested in the future. I know myself personally, when I was listing and selling, I know for a fact I was tested twice. Potential repeal of the 1031 like-kind exchanges. Now, I am not going to make this a Zoom call about taking a deep dive into 1031 like-kind exchanges, because they can get kind of complicated. And I have some bullet points here. What I want you to be aware of, though, is what the present administration is trying to do is to totally revamp this to the point where I believe investors are going to stop investing and trying to move up in property. A like-kind exchange is selling a certain type of property. Let's say it's a 2-unit apartment building, and I now want to buy a 4-unit apartment building because I have some equity in the property and I want to use it toward increasing my real estate portfolio. Basically, what this is saying, the 1031 like-kind exchange delays that capital gains until way, way down the line. What this is doing away with capital gains. So those capital gains taxes would be due immediately upon the sale. What this could happen or make happen in the real estate business is people just end up holding on to their properties, which once again, we get back to an inventory level issue. I'm not sure this addresses that issue. So keep an eye out for that. Finally, capital gains tax, it's been proposed to increase from 20 to 39.6%. I'm not quite sure why they didn't just double it to 40%, but 39.6%. Keep in mind that as a homeowner, you have an exemption when you sell your primary residence. If you're married of $500,000, single of $250,000, most likely this is not going to affect most people in Lancaster County until you inherit a property because of deceased parents, and now you have to put their property on the market. And oh, by the way, your capital gains has increased now from 20 to 39%. So once again, take a look at this. Keep a close eye on this. Once again, if you get these calls to action, take note. I also want to just share with you some recent things that I have seen from a number of different sources. This comes out from the Census Bureau. I just talked about this a second ago, where I don't think our problem in today's market is how many buyers are in the market. Let's pump more buyers into the market. The problem that we're having is there's not enough inventory out there. Now, what you see right here is a bar chart of what's occurred between 1970 and essentially 2010. And you saw between that time, anywhere between 10 and 12 million properties were pumped into the market. Look what happened in 2010 to 2020. This is the problem. There were only 6.5 million units. Now, a lot of this was kind of left over from the crash where builders got burned and they just really, really pulled back. But it's time that we reinvested in building. That's where I think the government ought to pay more attention to, because this is the lack of inventory that we're dealing with right now. Also, you are going to see some things, I'm sure, over the next probably 2 to 3 months that are probably going to wow you as a real estate agent and wow the clients that you're dealing with. And they're going to say, wow, just look at all this positive information. Here is a line chart that talks about, and by the way, this is nationwide. This is put out by move.com. New listings that are in the market. And by the way, all the way on the left-hand side, this is when the pandemic hit. And all the way on the right-hand side is where we are today. We are 53% less inventory than we were back when the pandemic hit. 53% less inventory. Now, you're also going to see something in the press that says, wow, look at all the new listings that are being pumped into the market. We're 40% over where we are pre-pandemic days. don't look at it that way. That's 40% over what it was in March of 2020. Do you remember how many new listings were being taken then? Like 0, because of what was going on, at least in Pennsylvania. So that 40% number increase is really, really deceiving. Just check into the numbers when you start seeing some of these stats. This came out, this was the National Association of Home Builders, and obviously builders take a look at this stuff because they belong to their association. Look what happened in the first quarter of 2020. In their survey, the home buyers that were planning to buy a home over the next 12 months, 10% of the population. Look what has happened to that over the last year. We're now at 16%. We have, and I think we all understand this, we have pent up buyer inventory. People want to buy homes. Once again, we have the issue is the supply side, not the demand side. Average profit for home sellers. The first quarter of 2020, the average homeowner, when they sold their property, was making just over $55,000. And a lot of people are saying, yeah, but I think the bubble's about ready to hit. Look at what sellers are making today. This is a 26% increase in 1 year. The amount of equity that people have in homes right now is so much better than what it was back in 2007, 2008, when you could get in, and Dan and James and I talked about this on a previous call, where people were getting into properties with zero money down, and it was a crazy world in which we live. That's not happening anymore. So this is a good thing. Here was a quote from the Wall Street Journal. Consumers were more upbeat about their income prospects last month, and many appear eager to spend. The survey found 8.9% of Americans plan to buy a home in the next 6 months. This is the biggest share in records going back to 1978. Once again, we have so many buyers in the marketplace, and buyers want to continue to enter this marketplace. Look at home price forecasts in 2021. You see a number of different entities here, from the Mortgage Bankers Association on the left to CoreLogic on the right. Virtually all of them are predicting at least or right around a 6.8% average for all forecasts for home prices in 2021, which bodes really well for sellers in the marketplace. And if we look at our industry, and you're looking at your industry, obviously as an agent who's in the real estate business, look what 2020 was like as far as the actual number of homes that were sold, 6.5 million in the US. And now look at the forecast from Fannie, Freddie, and the Mortgage Bankers Association for 2021 and 2022. 2021 were forecasted to actually do better than 2020, and 2022, if not the same as 2020, better. So for the next year and a half, we are looking at a very, very good market. Bodes well for those of us in the real estate business. So I want to end today's meeting by talking about client agency relationships. And I think we take for granted consumer notices, buyer agency contracts. Many instances, I know when I'm reviewing loops, a lot of these things aren't being actually signed until somebody's signing an agreement of sale, which is a problem. It's great that it's signed, but it's a little late in the game. I just want to remind everybody, this is what the Real Estate Licensing and Registration Act says. This is information to be given at the initial interview. A consumer notice shall be provided at the initial interview. For the purposes of this section, the initial interview is the first contact between a licensee and a consumer of real estate related services where a substantive discussion about real estate needs occur. Usually that's a long way, many instances, it's a long way before they're actually making an offer on the house. So how did we get to the point where we're even talking about a consumer notice? Many, many years ago, in 1993, I was in the business at the time. There was a company, and it still exists today, called Adina Realty. Adina Realty was a mega broker in the Midwest, in Wisconsin, Minnesota, Michigan. I think the Dakotas were part of that. At the time, early on in my real estate career, there was no consumer notice. There was no buyer agency contract. There was a listing contract, and everybody worked for the seller. Whether you knew it or not, you worked for the seller. So there were some smart attorneys in the Midwest after they got a number of complaints from buyers saying that they felt like they weren't being represented. They put together a class action lawsuit that was highly successful, that generated it was a $275 million lawsuit. And it involved over 6,000 transactions where buyers claimed that they didn't know that the agent that they were working with was being represented, or excuse me, that was actually representing the seller. So it was a big issue. I remember this at the time. By the way, this is pre-internet days. So we were getting monthly correspondence from real estate periodicals bringing us up to date on this. And when this hit the airwaves, almost overnight, all brokerages created their own kind of form of a consumer notice. So that's how we got there. So the reason why I bring this up today is most people don't get sued because of a consumer notice. Most agents have a consumer notice, but the problem that you have is when buyers and sellers are going at each other, and hopefully they're going through mediation first, but if mediation fails, then they enter their attorneys on either side. And it's, in my opinion, most attorneys will look at a case and they know almost right up front who's right and who's wrong. They can tell just by looking at the paperwork. So if I'm hired by either a buyer or a seller, and I know that they're probably, they're blowing smoke here and they're not going to win this case, I'm digging a little deeper in the file, trying to find things that are issues in real estate transactions. One of them is consumer notice. So when things go south, the transaction file is the fingerprint. So the file gets subpoenaed and they go through it with a fine-tooth comb. And if they see that a consumer notice is signed the day that an agreement of sale is signed, they're going to probably ask some questions. And sometimes you've been working with this person for a couple of months. So I make a note here. Depositions and investigations aren't something that you want to experience, especially if you haven't done this right up front. So let's start with the consumer notice. I do hear objections from agents saying, yeah, but it's a scary looking document. It is. It's a scary looking document, and people are really reluctant to sign these things. Here's what I share with the buyers and sellers that I dealt with over the years. First of all, I point out the very first line under consumer notice. This is not a contract. This is only a disclosure. And the second thing, which is right under this is not a contract, it basically says, hey, as a real estate agent, I have to give you this by law. I don't have a choice. I have to put this in front of you. Then it goes on to talk about different ways in which consumers can be represented. And the back page on the last paragraph says, be advised that unless you select a business relationship by signing a written agreement, the licensee is not representing you. A business relationship is not presumed. I would point these out to buyers and sellers, especially these areas that I've highlighted, and let them know, I get that this is a scary looking document. I'll take the time to leave it with you. You can read through it. I'd be happy to review it with you, but we got to get this signed up front, because if we go down the road, especially as a buyer, and you don't get one of these signed, I may not be representing you. And anything that you say to me, technically, I can share with the seller. Do you really want that to happen? So A number of years ago, I put together, this going way back into Prudential Homesale days, I put together the differences between a sub-agent and what a buyer's agent does. And I'll include this with the stuff that I send out because you ought to know what the differences are. If you're a sub-agent, your actions and how you deal with buyers is different than as a buyer's agent. You ought to know what the benefits are, and you should be able to clearly explain what the differences are between having a buyer agency agreement and not having one. And by the way, if you can't explain the differences, how do you expect the buyer to feel comfortable signing a buyer agency contract? The other thing that is available to you, it's in .loop, it's called our buyer services guarantee. It's in our standard buyer template. I know some people get this filled out, but once again, it just reemphasizes all the things that you're doing for the buyer that kind of sets you apart from other people. It's a tool to be used. Explain what the advantages are working with you, and link it to the buyer agency contract. And the buyer agency agreement itself, this ensures that we get paid. I got to tell you, over the years, I've had agents walk into my office and ask me, hey, I just had a client buy a house through so-and-so. I've been working with them for 2 months. Do I have any recourse here at all? If you don't have a buyer agency contract, it's pretty tough to collect a commission. It outlines what you are going to do for the buyer. And remember, we just saw it in the consumer notice. Unless a buyer signs a buyer agency contract, you represent the seller. And I added a caveat here, maybe. There are certain rules in law that basically say, hey, if you're acting like a buyer's agent, even though you don't have this signed, you may end up being a buyer's agent. But I always go back to the point, if you get it in writing, there's no question. There's no question. So here's some buyer objections that I hear from agents that they share with me. The client says, or the customer in this particular case says, but I don't want to be tied to you for an extended period of time. And I typically share with buyer agents, it doesn't have to be forever. Unlike a listing contract, a buyer agency contract, do it for a short period of time, maybe as little as a week. Now, once again, when I say a week, make sure you're explaining to the buyer all the things that you're going to be doing for them, because hopefully you're going to be setting yourself apart from any other agents that they've worked with in the past, and they'll want to re-up that contract with you after that week is done because they've gotten an opportunity to touch and feel how you do business. Here's another objection. But I didn't have to do this with another realtor when they showed me some properties. And I typically say to the buyer, you do understand that they were representing the seller, correct? And just let that sink in. And anything that you said to that agent, basically they were representing the seller. I'd like to represent you in your interest. And here's an objection, but I could end up paying you a commission if I buy a FSBO, for sale by owner. Yep, you absolutely could, but you're going to know it going in, because me as a buyer's agent, I'm going to go to the for sale by owner and say, would you pay commission? Would you pay my commission? Because if you won't, I'll go back to my buyer client and I'll explain that they would be owed the commission. And I got to tell you, Mr. and Mrs. Seller, if they're going to be responsible for the commission, they may not want to see your house. Let that sink in. So as you're getting these objections, as you're working through some of this stuff, if you get objections, come and see Colleen or myself. We'll be glad to work with you on how to answer some of these things. And I'm going to leave you with a couple of other things here. In fact, I'm going to skip through this because we're getting close to the end here. Just some questions to ponder. I'm not going to give you an answer here, but just think about it. Can you show a property to a buyer without a buyer agency contract, and prior to writing a contract on it, become a buyer's agent? How would an attorney look at that? Because if you're showing property to somebody without a buyer agency contract, and then all of a sudden turn around midstream and get one signed, are you switching hats? I wouldn't want to be in your shoes if an attorney's talking with you. And another question, if you show a property to a buyer without a buyer's agency contract, and the MLS printout indicates the seller is only willing to compensate buyer's agents, are you entitled to a commission if you sell the property? Just think about it. All I wanted to do with this segment on agency is to just raise your level of awareness. With how fast things are moving, sometimes we just brush things off. These things are important. I know, once again, you're dealing with buyers that want to move and shake really fast. Take the time to put this stuff in front of them and get their signatures and get their buy-in on it. And our inspiration for the sales meeting, this comes from Deepak Chopra. Instead of thinking outside the box, get rid of the box. There's a lot of stuff happening in our industry that is going to require you to just climb out of the box. Think about it. It is 12 noon. Hope everybody had a good week thus far. Have a great day. And if you have any questions on any of these protocols that I talked about here in this meeting, please come and see me. Be happy to talk with you about and show you my binder of the 57 changes and protocols that we've gone through since the beginning of time. Thanks, everybody.
Thank you, Tom.